In 2001, the California State Assembly passed a resolution in support of reparations. And also in 2001, a bill was introduced in the New York State Assembly to create a commission to quantify the debt owed to African Americans. NCOBRA chapters throughout the country encourage city councils to endorse H.R. 40 with the passage of successful resolutions in Pine Bluff, Arkansas, the California City Councils of Alameda County, Berkeley, Compton, Foster City, Inglewood, Los Angeles, Oakland, East Palo Alto, and San Francisco, the District of Columbia, Atlanta, Georgia, Chicago and Evanston, Illinois, Baltimore, Maryland, Detroit, Michigan, Jackson and Claiborne County, Mississippi, St. Louis, Missouri, the New Jersey City Councils of Camden, Passaic County, Patterson and Newark, Cleveland, Ohio, Philadelphia, Pennsylvania, Dallas and Fort Worth, Texas, Burlington, Vermont, Richmond, Virginia. All of these legislative mobilizations occurred over 2 decades before candidates vying for the 2020 Democratic nomination took center stage. The strategy advanced by NCOBRA over 30 years ago achieved its goal of making reparations a household word. And it's now past time to bring that household word into reality. I am a part of the inaugural cohort of commissioners on the National African American Reparations Commission, NARC, convened in 2015 by Dr. Ron Daniels at the Institute of the Black World 21st Century. NARC, under the leadership of fellow Commissioner Cam Howard, current co-chair of NCOBRA, revisited the strategy of the 1989 Reparations Study Commission bill and proposed to Congressman Conyers that the legislation be updated from a mere study bill to a remedy bill. Thus, in 2016, the bill was revised to also incorporate the actual development of reparation proposals, now titled the Commission to Study and Develop Reparation Proposals for African Americans Act. And in addition, NARC has advanced a comprehensive yet preliminary 10-point program to guide reparatory justice demands by people of African descent in the U.S. Although my primary focus is obtaining reparations for the descendants of Africans enslaved in or subjected to Jim Crow laws in the U.S., it is important to recognize that the pursuit for reparations in the United States is also part of the international movement for reparations. As such, I've worked closely with supporters of reparations throughout the world, recognizing that the success of the movement for reparations for diasporic Africans anywhere advances the movement for reparations by Africans and African descendants everywhere. I am thrilled that my quest to have reparations seen as a legitimate concept for Black people beginning when I was a teenager during the 1970s is today becoming a reality. And while cash payments remain an important and necessary component of any claim for damages, the harms were multifaceted, thus the remedies must be so as well. A reparations settlement must be fashioned in as many ways as necessary to equitably address the countless manifestations of injury sustained from the enslavement era and its continuing vestiges and living legacies that collectively comprise a crime against humanity. In conclusion, Queen Mother Audley Moore has been crowned as the undisputed mother of the modern era reparations movement in the United States. And although the genius and role of Brother Imari Obadele played is largely absent from the popular annals of reparations lore, he has been acknowledged as the movement's father. And the story of Queen Mother Dorothy Lewis has yet to be written. I am inspired by the memory of the three of them, and as I conclude, I will call their names in libation, and please repeat after you hear their names, if you so wish, the word Ashe, which means also, so be it. Queen Mother Audley Moore, Ashe. Let's see if we can get this, see my little libation there. Okay. Brother President Imari Obadele, Ashe. Queen Mother Dorothy Lewis, Ashe. Belinda Royale, Ashe. Henrietta Wood, Ashe. Callie House, Ashe. Isaiah Dickinson, Ashe. Marcus Garvey, Ashe. Elijah Muhammad, Ashe. Reparations Ray Jenkins, Ashe. Chokwe Lumumba, Ashe. Ahmed Obafemi, Ashe. Christopher Alston, Ashe. Dara Abubakari, Darcy McIntyre, Ashe. Cannibal Afrique, Ashe. Njeri Algani, Ashe. Kalanji Olusegun, Ashe. Kwame Afo, Ashe. Milton McGriff, Ashe. Dr. Ronald Walters, Ashe. Herman Ferguson, Ashe. Omawali K. Ashe. Erlene Arikpo, Ashe. Nia Kumba, Ashe. Marilyn Killingham, Ashe. Conrad Warrell, Ashe. Aldari Ali, Ashe. Askia Muhammad, Ashe. State Senator Bill Owens, Ashe. Congressman John Conyers, Ashe, 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 as well as the so many countless others who never made it into the history books, but upon whose ancestral shoulders we firmly stand in our long standing journey for reparatory justice in this country. Ashe.
Ashe, thank you so much, Nkechi Taifa, for that incredibly moving and powerful testimony. We will now turn to Ms. Ajua Ayatoro, and then we'll turn to questions and comments from our course members. So thank you again, Ms. Taifa and Ms. Ayatoro. You may begin your expert testimony when you're ready. Thank you.
Thank you. Thank you very much. I'm like Nkechi. I can see me over here, but I don't know. Can you see me?
Yes, ma'am.
Okay. Thank you. Thank you very much. And thank you to my sister Nkechi for a very uplifting historical account. And I really appreciate that, as I'm sure the task force does as well. I'd like to start with highlighting some of my experiences that directly relate to the task force's charge, although all of my education experience and life experience actually does relate to and significant relevancy. I worked at the United States Department of Justice Civil Rights Division Special Litigation Section from 1978 to 1981. One day I saw a poster while walking back to my office that had a picture of Uncle Sam pointing out at whoever's walking by with the cryptic words, "Black people, Uncle Sam owes you X trillion dollars." I leave the amount blank because I no longer remember the amount. I just remember it was trillions. My soul immediately responded, yes. I have been an active participant in the reparations movement for African descendants since that time. I'm a co-founding member, as Nkechi pointed out and is in my bio, of the National Coalition of Blacks for Reparations in America, NCOBRA. And I was co-chair of the National Conference of Black Lawyers in 1987 and 88 when NCOBRA organized. NCBL is a co-founding organization. After serving one term as founding co-chair of NCOBRA, I became the chair of its Legal Strategies Commission. In that capacity, I led a group of lawyers and activists in examining how litigation could be used to advance the demand for reparations. One of the things that we did in the beginning of NCOBRA, which was both not just the Legal Strategies Commission, but the whole of NCOBRA, was to reach out to the more mainstream organizations, because as Nkechi pointed out, many of the organizations that came to the fore, with the exception of NCBL, were long-standing organizations in what we would call the nationalist community or Pan-African community. NCBL was kind of, had some nationalists, but was not known as a nationalist organization. It was a Black legal organization that had more left-leaning than anything. But we reached out, and we say members of the organization. Dorothy Benton Lewis was a member of the Deltas. He reached out to Deltas, and Deltas came on board. I was a member of NCBL, but one of my good friends was on the board of trustees of the National Bar Association. We reached out, and they came on board. And there are many others, and I don't want to spend time doing that, but I want to support the view that in NCOBRA, broaden the groups and organizations, individuals that embrace reparations, from a call for or demand that was largely lodged in the nationalist community to one that began to be spread throughout the various communities, if you want to identify them by ideology. Randall Robinson's book in 1990, I think it was 1990, 1991, came out of that expansion. It was an excellent book, but it can't be looked at in isolation from the rise in interest. And we know across the country, universities, churches across the country, everywhere, we're beginning to talk about it because, as Nkechi pointed out, the work that was being done largely by the Legislative Commission, but also in COBRA broad base, to take the demand into the public arena. As a practicing attorney with the U.S. Department of Justice and the ACLU National Prison Project, I developed the skill of assessing the validity of claims made by prisoners and their supporters concerning conditions of confinement in state and federal prisons. I determined whether these claims, if true, violated the Constitution of the United States. I developed the skill of identifying what facts were needed to prove the constitutional violations that were asserted. As a law professor, I taught, among other courses, remedies at law and in equity. I taught students how to determine what relief is appropriate for any number of claims, including claims for redress for injuries caused by historic violations. The starting point for my charge in this panel on the history of reparations is really to define the term. What are reparations? Black's Law Dictionary defines reparations as the redress of the injury, amends for a wrong inflicted. United Nations resolutions and reports identify it as a remedy for wrongs to and injuries inflicted on a group based on their group identity. Examples of reparations to victims of the Jewish Holocaust in the state of Israel. Reparations to 15,000 former students of Canada's Indian residential school system. Reparations to the survivors of the British torture, including sexual abuse and castration of the Mau Mau, and the internment of Japanese Americans in World War II by the United States. Reparations used in ordinary legal parlance means to provide the remedy that puts the person in the place she would have been but for the injury. Money is only used when that is either what was taken or what was taken cannot be returned and its value is calculated. The matter you are addressing is whether and in what form reparations should take for slavery and legacy of slavery in California. That question was addressed as well in the United Nations resolutions and reports. I refer to these rather than documents of the United States because the United States has consistently resisted addressing the call for reparations and thus has no articulable doctrine on what it entails. Although, as I mentioned later, we can draw something from Japanese American Restitution Act, the United Nations in the documents produced from the World Conference Against Racism, Xenophobia, and other related intolerances identified slavery as a crime against humanity and suggested remedies for the victims of crimes against humanity that included slavery. The 2019 report of the Special Rapporteur on Contemporary Forms of Racism, Racial Discrimination, Xenophobia, and Racial Intolerance addresses the human rights obligations in relation to reparations for racial discrimination rooted in slavery, the legacy of slavery. It's consistent with your charge under AB 3121. The Special Rapporteur indicates that governments have a basic reparative obligation to make full reparations for injury caused by wrongful act committed by that government, whether material or moral. Her report also underscores the responsibility of governments to wipe out all consequences of the act and to reestablish the situation which would, in all probability, have existed if that act had not been committed through the provision of one or more of the forms of reparations. These forms are restitution, compensation, rehabilitation, satisfaction, and guarantee of non-repetition. The return of property taken either during slavery or based on processes that are the legacy of slavery is restitution, a form of reparations. Compensation for unpaid labor during slavery and the underpayment for labor that is a legacy of slavery is a form of reparations. The valuation of the return to Africa, the trip and establishing them in a country for those who were kidnapped and their descendants is restitution, a form of reparations. The NCOBRA Legal Strategy Commission studied slavery and its legacies and determined that there are 5 major injury areas: peoplehood, education, health, including mental health, criminal punishment, and economics, that includes wealth and poverty, peoplehood, the act of taking away the group's right to its language, family structure, and right to speak as a group. In 2022, voter suppression based on race flows from the injury to peoplehood. Education, the enslaved were denied the right to learn. In many states, teaching an enslaved person to read was a crime. In other states, the learning was restricted. After enslavement, Black schools had poor structural conditions and materials than those provided in quotes, white schools. There continue to be inequalities in education based on the legacy of slavery. Health. The quality of health care during the enslavement was based on the value the so-called owner placed on the enslaved person. Volumes abound that document the racial disparities in health that can be attributed to the structural racism and the conditions of life of Black people, as well as discrimination in the provision of health care. These are legacies of slavery. Criminal punishment. The enslaved were at the mercy of whites who could punish them for any behavior they determined was offensive. Punishment was violence against the body generally. The foundation of the modern-day police is the slave catchers. Law enforcement has a history of targeting Black people and treating them more harshly. The legacy of slavery. Wealth. The very nature of slavery was to force Africans to work for nothing. The exception to this, the rare occasions when an enslaved person received some payment for his or her work, were largely at the discretion of the person who paid the enslaved person. Land that was rightfully owned was taken, and the continuing legacies that flow from slavery, including discrimination in education, employment, ability to buy property, have created a lower economic base for Black people, and is a continuing legacy of slavery. Who is to be repaired? A lot in the discussion about eligibility. The Incover Legal Strategies Commission spent many hours discussing this question. The class of recipients of reparations for slavery and its legacy should include descendants of enslaved Africans and those who are suffering the continuing harms from slavery's legacies because of being identified as Black, African American, or African descendant. It is a misnomer and legally erroneous to call enslaved Africans enslaved African Americans. Enslaved Africans were not citizens of this United States, as Nkechi has pointed out, until the passage of the 14th Amendment. This is not a preferential position. It is legally accurate position. The history of litigation in seeking reparations, I'm sorry that our sister Deidre Former Pellman is not here to talk about the case that she led, but her testimony would have illustrated that the efforts to obtain reparations for slavery and its legacy through litigation have been primarily unsuccessful, except for the very early cases that Nkechi lifted up. This is due to procedural hurdles. The legislatures and courts have adopted that the litigator must jump over in order to try the case on its merits. In Deidre's case, standing. Other cases, statute of limitations. The courts have recognized the principle, however, of providing relief for a continuing injury, one that traces back to the original harm. However, procedural hurdles must still be overcome. The Legal Strategies Commission also considered reparations as critical to healing racial divide created by enslavement and its continuing legacies. I have published an article about reparations as essential to establishing a true democracy. And when I send my narrative in full to the committee in the next day or so, I will attach some my reference to those articles and others. The crime of slavery and its continuing legacy sit at the feet of the government. Slavery and its continuing legacies have targeted a group because its group identity is African, African descendant, or Black. This targeting has caused significant injury. The murder of the many Black people by the police throughout the United States, the differential treatment of Black people as I've indicated above. Money reparations and only to descendants of Africans enslaved in the United States or in California, since you all can't do it for the whole United States, wish you could, is an insult to the enslaved Africans as it diminishes the magnitude of the injury caused by enslavement. It also constricts the recipients of even those money reparations to people who can somehow prove they are descendants of enslaved Africans. What about people who look like me, who cannot meet a standard of proof that they are descended from an enslaved African? Even more concerning, what about reparations for the legacy of slavery? Money reparations do not address a key charge of the legislation to address the legacy of slavery. And in addressing the legacy, the recipient group, to have any credibility, must be larger than those who can demonstrate they are descendants of enslaved Africans. People who look like me, but are not descended from enslaved Africans, suffer the injuries of the legacies of slavery. That is the major crime of slavery and its legacies. It imprinted on people who look like me a presumption of inferiority, a presumption of criminality, a presumption of loose morals, a presumption that leads to being unable to obtain jobs and housing of the same caliber as so-called whites. Money reparations to only those who meet a burden of proof of descending from an enslaved African leaves those who are victimized by the legacy of slavery with an injury without a remedy. Reparations must include systemic remedies. A blow to structural racism that is a child of slavery and the politics, practices, and beliefs that supported the kidnap, chaining, dehumanization of a people simply because whites saw them as objects of commerce that would increase their wealth simply because their skins were dark and their culture curious, simply because they were viewed as other, simply because. You have a challenge, an obligation to look at this in whole cloth, to not be a victim of perspectives that devalue and diminish the injury to the descendants of enslaved Africans and to African descendants more generally in California. The Legal Strategies Commission grappled with the question of the amount based on the concerns expressed to us that the check will be too big. Both individual checks to those descendants from enslaved Africans and the check needed to correct, remedy structural racism that is slavery's legacy. The legacy of slavery, structural racism in the major institutions and infrastructures in California continues to disadvantage Black people. I have an analogy that I'm not going to go into because you all know your personal budgets. You know how much money you bring in. And you know those of us who try and be responsible do a budget. But there's some people, they don't have enough money to do a budget. So they just hit, whatever's the first thing on the table. But in budgeting, we put the whole cloth together. And then we look at our money and say, okay, I have to pay rent or pay the mortgage. I have to buy food. And maybe the roof can wait till next year. So that's, to me, your charge, or maybe I'm giving you a charge, I don't know, but AB 3121, when he talks about the legacy of slavery and it talks about reparations for it, let's do the whole cloth. Don't narrow it before you even get started, which I'm sure you're not doing, but my passion for it and my concern is all the work we have done in Kichi, even before I joined in the mid-'80s, and others she lifted up. We cannot cheat the ancestors, deny our children and those children to come the right to know the full scope of injury. And then then reparations can be prioritized, would be my suggestion, based on what has to be done now and what doesn't have to be done now. And there are other ways of doing it. For example, in Maryland, they're doing a trail of enslavement that shows where the various slave points were, enslaved points. I don't like the word slave. And Mario Verdelli taught us many years ago that we were not slaves, we were enslaved. And slaves, it deteriorates our status as a human being. So then let's just look at, it seems to me, a full accounting of the injury honors our ancestors and African descendants. Nkechi lifted up the names, and we didn't know she was going to do a libation, but thank you, Nkechi. And therefore the spirits of those who are now ancestors. There are others who have boldly lifted up this demand for 30 years or more, and there are those who have embraced it more recently. A decision on what will repair the injury cannot be made without the fullest record of the injury that can amass. And I know from talking to Dr. Grills and others that that's what you all are doing. That is why NCOBRA's Legal Strategy Commission spent a couple of years reviewing, discussing, and identifying the major injury areas. To us, it would have been irresponsible to simply say give every African descendant a check for a certain amount. The compromise, what appears to be a compromise to me, in the Japanese American Restitution Act, It said all of those who were interned and alive at the time the bill was passed received a token payment, and I say token because it was a token, of $20,000 each. They received other forms of reparations as well, which still may not have been adequate, but there were other forms. This was not a calculation of injury, the $20,000 individually, but a token payment. So once you have completed amassing the injury information, you can look at the definition of reparations and its forms provided both by the UN Special Rapporteur on Race, as well as other scholars and advocates, and determine what are the best forms of reparations to repair the injury. We know in law that it is difficult to make people whole and that money is frequently the substitute when what has been taken cannot be replaced. Yet we also know that the institutions that are the children of slavery and continuous legacy can and must be part of the reparative remedy. Remedy the legacies of slavery. The charge you have requires you to consider the future African descendants and recommend reparations that will dismantle the structural racism that, as the esteemed Charles Ogletree said about criminal punishment system, is an unbroken chain from slavery. A check alone does not even touch the repair of the legacies of slavery. It does nothing to repair, to eliminate the systems that have been put in place on the backs of slavery, to continue to treat African descendants as other, as subordinate to whites. We all know that the legacy continues. We know you have the courage to identify and clearly this injury, and then to recommend ways to repair these injuries. Much has been written by social scientists, health professionals, criminal punishment professionals and experts, economists, and more. We want you to, we praise you for taking on this charge. We praise you and honor you for being willing to step forward and to do this very difficult task. And we ask and that you consider us, those on the panel, and I'm sure other panelists, to be continuing resources to you. But we ask you to really look at the major injury that flows through all of the continuing racial discriminations that we experience, is the injury of the lie of white supremacy and the lie of Black inferiority. And that is what emboldened them to have slavery, to institute it against our people. And that's what emboldens them now when they look at a Black applicant for a job and they look at a white applicant for a job, and they continue to do what was done to my father. Black applicant for a job in the 1940s during World War II at a drug company, bachelor's in chemistry, bachelor's in math, and the job was given to a white high school graduate. This is a continuing legacy. My family is descended from enslaved Africans, but I believe it would not be of service to only identify the beneficiaries of reparations as those who can trace their history back, because we missed the point that the United Nations documents talk about and that people are talking about. We missed the point of the legacy that must be attacked and must be addressed. Thank you very much for your time and your work.
Thank you so much, Ms. Ayatorio, for your informative and inspiring expert testimony. So it is now 11:28, and we have about less than 30 minutes or so for comments and questions from our esteemed task force members. And so now I would like to take a moment to invite any of our task force members to provide any comments or questions to our panelists.
Madam Chair.
Vice Chair Brown, you're recognized.
Are you recognizing me? Hello?
Yes, sir. Yes, you're recognized, Vice Chair.
Madam Chair and members of the task force, we are greatly blessed and very much informed by the excellent presentations that have come from our sisters. And as the old guru historian, I want you to indulge me. Let's go back.
Vice Chair,
indicate. Can you hear me?
you were spotty, but we can hear you clear now.
Yeah, I said it's necessary for us to specifically indicate that when the Confederacy would not give up, and General Sherman and Secretary of War Stanton moved down to Atlanta and burned down Atlanta. And amongst the spots that were burned down was a campus where the present day Morehouse College exists. The record reveals, friends, that as Sherman and Stanton marched to the sea, was General Sherman who asked Secretary of War Stanton, what are we going to do with these ex-slaves, as they were called now, but we know it's enslaved today? Stanton said to General Sherman, wait until we get to Savannah. And when we get to Savannah, we will call a meeting with the black preachers there, for they are the leaders of the community. And when they got to Savannah, there was a meeting called in Sherman and Stanton's hotel room with 20 black preachers. And the chairperson of that meeting was one veteran preacher, Baptist preacher, Garrison Frazier. And General Sherman asked him, what do you feel the Union owes these ex-slaves? And the old man said, I can't speak for everybody, General, but at least for me and my house, I think we deserve having 40 acres and a mule so that we will be able to build communities, educate our children, and be self-sustaining. And then he asked, do you want to live amongst the whites? Or do you want to stay to yourselves? Again, the old man, Frazier, said, General, can't speak for everybody, but I'd rather stay to myself, because this thing of evil against us because of the color of our skin is so deep that it'll be a long time before we'll be accepted as being human. I cite all to say this. That happened on January the 12th, 1865, in that hotel room. And we should tell it to our children that field order number 15 was issued because that black Baptist preacher opened his mouth and spoke truth to power way back there. In addition to the truth that's been spoken by subsequent persons whom you have very ably lifted up this morning. Thank you for your presentation, but don't forget there was that black Baptist preacher, Garrison Frazier, who opened his mouth and wasn't scared to speak truth. And he was not an embracer of slave religion. He was a liberating black preacher. He was about the betterment of the people. Thank you, Madam Chair.
Thank you again, Vice Chair Brown, for offering that testimony and historical context. And I believe that historical context is already posted on Twitter, so thank you for adding that. Any other questions or comments from our task force members about what we heard from our two illustrious panelists?
Okay.
Sorry, I can't see everyone's faces, so feel free to speak up. I did have a question. I believe reparations rate was mentioned. Given the ceremonial and educational nature of today, would any of the two panelists kind of just, for my own maybe personal edification, but for the public, kind of share a bit more about who he was and what he did?
Oh, it was a he. Reparations Ray Jenkins was perhaps one of the most consistent, loud voices calling for reparations from a very, very long time ago. He was a Detroit native. He would always call up to Councilwoman Joanne Watson's radio show talking about reparations, and he talked about it so much that she nicknamed him Reparations Ray Jenkins. He was always in Congressman Conyers' ear, always talking about, when are you going to bring up a reparations bill? When are you going to deal with reparations, etc. So it was largely because of his consistent insistence, coupled with the recent passage of the Civil Liberties Act of 1988, and coupled with the founding of NCOBRA, that Congressman Conyers was inspired to go on and introduce that bill. And one other thing I would say, I remember at one point, Congressman Conyers staffers would say that they received more mail, more information. This is before the internet, y'all, so it wasn't email, but more mail about reparations, the issue of reparations, than any other issue that he was dealing with. So even back then in those early days, it was a huge issue. And Audra, I don't know if you want to add anything more about our brother, Reparations Ray Jenkins.
I could just ask a couple of things if it's okay with the chair. Chair Moore?
Please, thank you so much.
Okay. Two things. One, he was a real estate, he was in real estate. I don't remember the top point, but he owned a real estate company, was in real estate in Detroit. The second thing is he was primarily responsible after NCOBRA was founded. And I mentioned that we went into various organizations, the National Bar Association, Delta Sigma Theta, other sororities and fraternities. But he went to the NAACP. He was a big member of the NAACP, and he and other members of NCOBRA Detroit chapter went to the convention. I think it was 89 or 90, I can't remember what year. And that delegation is largely responsible for the NAACP embracing reparations, creating the legislative division that is now headed up by, Nkechi, I'm blanking on the name of the person, as well as I know he's from St. Louis, which is where I'm from, so I feel terrible. But heading that up, and it continues. The NAACP continues to have the legislative work around reparations as a major part of their work. So he was significant.
Hillary Shelton?
Yeah, Hillary.
Hillary Shelton.
Yeah, Hillary Shelton. I couldn't. Lord help me. Woo.
It's all right.
It's not the gray hairs, y'all. I'm sorry, it's not the gray hairs. But I think that's important to lift up. I don't know if anything else you have, any other people have any other questions?
This is Lisa Holder. Chair Moore, just wanted to, I don't know if you can see me.
You're recognized. I don't see you, but you're recognized.
Yeah, thank you both so much for that dynamic history lesson, which is really sort of sustains my commitment to this movement, just thinking about it from this historical perspective that you presented so eloquently. I also wanted to ask Ajo Ayatoro, given your work with the DOJ, your background as an attorney, I wanted to get your insights on focusing on lineage versus focusing on the continuing harm of the legacy of slavery, which is anti-Blackness, right, and white supremacy. How are those two different from a legal perspective? And I just wanted to get your sense on that, on what is a more viable strategy from a legal perspective.
Well, thank you very much, first of all, for that question, because I know that just listening before we came on as a panel to some of the comments, there's a strong support for just focusing on the descendants of enslaved Africans, but there are others who support a broader perspective. I believe legally, based on my experience, both directly working on developing reparations claims, but also more generally in terms of my legal experience and knowledge, I think that you can do both. I don't think you just have to do something that is the lineage from enslaved descendants of enslaved Africans. I think you can do both. I think we see models of that in many ways. We see it in, even though, we realize that we can't have a remedy that pulls out only only Black people or Black Americans when the injuries are general to everybody. That's a principle of law. I'm trying to state it in layman's terms. And I disdain a lot of legal terms anyway. I used to teach my students to speak as if you're talking to a 12-year-old, because most times the person who was dealing with it in law in the court may or may not really have the judge might, but many of the clerks don't have a full grasp of all the legalese, and people understand what you're talking about. So I do think that in law, you can, in fact, I know, based on my studies, that you can develop a reparative package, a reparative program that identifies things that are based on the legacy of slavery that aren't specifically tied to having to be a descendant of an enslaved African. But the legacy of slavery, the legacy, and you can look at in your systems in California. I'm not as familiar with California, and not trying to say that I am, but I dare say we know that there are probably issues in education that you can link to the legacy of slavery. I think that it's a false dichotomy that is being attempted to be made. I understand. I know you're going to speak in another panel to Professor Chemerinsky. I think that there are some differences that some people have with his viewpoint, and it's unfortunate. I understand that he's the only one on that panel. But I'm more than happy. I did share some names of people that you could speak with or maybe could enlighten you. The law of the land is not, United States law is not going to say, whoopee, just come on in here and y'all can do whatever you want and it's okay. Because the law of the United States and the law of any country narrows how you can get into court and narrows what your claims are based on. But if you base your claim that you are doing reparations for the legacy, in addition to for the slavery, and also you are doing it for the legacy of slavery, and do that what as I mentioned, Charles talks about the unbroken chain. Show how health, show how education, show how whatever those components. I know you're going to hear from some people around criminal justice or criminal punishment. You've already heard from people around health. But if you show the linkage, if you show the unbroken chain of it, which you can, and many of us are willing to help you do that if you need us, then you, I think, are on solid ground. The second point I want to make is, for me, as a reparationist, as a legal activist, I always put forward the big picture. One of the problems, I think, in our movements, and I have to say, I think some of our, civil liberty organizations were guilty of this around the crime bills. We want to negotiate before we have to negotiate. So we shrink our demand based on what we think they may do. And my way I present, both as a litigator, as a legal activist presenting to groups. I was with the World Conference Against Racism. I represented the Women's International League of Peace and Freedom, and co-chaired the African Descendant Caucus there. And what we did was present the big picture. What we said is, if the General Assembly is going to cut it down, it's going to cut it down from what we want, not from what we think they're going to agree that we want. So for me, you're on solid ground if you link your legacies to the injuries, because as I read to you, and then I'm going to attach when I send my narrative, the resources that I refer to that you may want to look at later. The charge internationally, as well as your charge, as I've read it in your document, is to deal with the legacies of slavery. The legacies of slavery aren't just tied to somebody who can trace their ancestry. They didn't ask Diallo when they shot him 40-some times and murdered him whether or not he was an enslaved African. But his death and the deaths of so many. George Floyd, I don't know what his legacy is. I don't know if he was a descendant of enslaved African, but George Floyd clearly is part of that unbroken chain. And so I think you can do it. I know you can do it. And my view would be that you make your case as long as you link it, as long as you can link it. You know, you're not trying to give reparations for something that you can't even articulate as a legacy of slavery. And my last point, and I'm probably, all this bubbling up, I'm just so happy after, and Keisha and I said, after all these years, to be here, we never would have dreamed it. And it's just exciting to see you all and see your faces and know that you are digging down and doing the best you can to do what you think is right. But the last point I want to make is that your remedy did not just be money. I think, and Kishi touched on that, I've touched on that, I'm sure others have touched on that. Because money doesn't wipe out or address, even if we can never eliminate them all, I don't know, I'm an optimist, but you know, if money can't do it. Money can only say, it's like damages in a case. I got hit by a car. I can't, you know, you can't put my arm back together. So you give me what the doctors say or the lawyers say is the value of my broken arm, right? I mean, that's very simplistic. But you've got legacies of slavery in all your institutions in California. What can you do? What can you recommend as reparations to address the ongoing legacies that continue to marginalize Black people, that continue to keep us in second-class citizens, as Derek Bell would say? Derek Bell argued that we'd always be second-class citizens. I fought that argument but I feel that maybe we will be if we don't bite the bullet and really reach for the just claims, whether or not some court decides it's not or not. Look at what they've done to affirmative action. It still stands, but they whittled it down. But if we started with it whittled down, we wouldn't have it at all. So thank you. I'm sorry talking so long, but you hit my button. I'm sorry.
So I'd like to just very briefly address that question of Commissioner Holden. I agree 100% with Adjoa that the lineage issue versus current day legacies is not an either or, but a plus and. But the weird thing about it is that issue never came up in the past 35 years prior to a couple of years ago. In fact, I've never even heard any immigrant saying, I want this money. I'm not even sure where it would. I have just been very surprised with the amount of vehemence that has attached to this issue that didn't even seem to be a real, issue, to having encountered such negativity, I guess you could say. I will say this, that the reason I say a plus has also, it could be a situation where, okay, well, maybe if you want to deal with a lineage issue, maybe you should look at it as a rebuttable presumption, which is a legal term. But it's like, on my father's side, he does not know who his actual lineage father was. Okay, I don't know who my grandfather was on my father's side, or even beyond that. I just knew that they were born in North Carolina, and, I just presume the presumption is, we came from the enslavement. Don't know what plantation, don't know ABC, DEF, none of the above. And to require me to have to take a DNA test or to go through the Census Bureau or whatever, to me, it's an oxymoron, because many people who left the South or went for the Green, they were trying to take away those slave names, okay? They were escaping from the Klan, or they weren't necessarily beholden to what was not their identity. So I cannot say forthrightly that even if I knew who the ancestral lineage was, that name would have shown up on the Census Bureau. During the enslavement time, folk were identified just by first names. And every time they were sold, they got a different first name. and a different last name. So at this day and age, to call for a reliance solely on a lineage, just does a disservice to where we are today in 2021. So as a result, maybe, a rebuttable presumption, okay, which you can rebut, say, hey, y'all, you just came over here, you didn't, and then it might be a different phase of the remedy that they would accrue. And so, I mean, I don't know. I'm just saying that to just have a bright line like that, that does a disservice. That's it.
It also, I'm sorry, but it also dawns on me that it doesn't afford us the opportunity to do one of the main forms of reparations, which is non-repetition. Because if all you're doing is the form of reparation is non-repetition, and we see that in the Holocaust. The Jewish people always hold up, never again. Well, you cannot say never again if you narrow it to one little group that can show by whatever means that they were descendants of enslaved Africans. You won't meet reparations. It's not reparations. You're just giving them individual reparations, and that's fine. But reparations, if you're going to look at it in the broad definitions that the UN and others have embraced, you can't do that. You cannot end the legacy of slavery by only addressing those direct descendants of enslaved, because the legacy is bigger than the direct descendant. We're living with it now. So thank you, Commissioner Holder.
Thank you both.
I have a question. I don't understand. Where's the chair? I'm trying to make.
Your internet is unstable. So go on.
Oh, okay. My question is, she said several times that this was a ceremonial panel. I'm not sure what that means and how our testimony then would be used if it's merely ceremonial. Do you all not? I won't talk anymore. I talk forever, but that's my question.
Either this is my.
Okay, go ahead. Go ahead, Javon.
Okay. Well, what we're doing today is effectively, honoring folks like yourselves who have done the work advocating for reparations. And so, I think the notion of it being ceremonial does not diminish, the kind of influence and impact that your testimony will have. So what we're talking about really is a recognition of your efforts. So hopefully that clears it up for you.
Yes, thank you very much. Recognition of our efforts would make me feel so good if y'all come out with the reparations proposal. So that's recognition for all the work that we have done. Nkechi raised up names to us, to me, and I know Nkechi, even though I try not to speak for other people, but I can say I know for Nkechi that this work is heart work, and it's almost like being called to the ministry, and maybe it is like that. And so I'm very grateful for your work. And I'm very grateful for, I know, the hard discussions that you have had and will have. But thank you for saying that we're part of this. We're ceremonial. We're lifting up Nkechi. They're lifting us up. Thank you.
But we want to be looked at as experts as well.
No, I know. That's why, because we are experts. I'm sorry, I don't mean to toot our own horn, but we are.
Hi, sorry about that. Didn't mean to interrupt if there was a conversation going. Was there any comments or questions to our panelists? Okay, if not, I had a clarifying question. So at our last January meeting, We had Secretary Weber, who was the lead author of AB 3121. She came to the task force to clarify her personal intent as to who she felt was eligible based on the bill. And essentially, in her words, to paraphrase, I believe she said special consideration should be for descendants of enslaved Africans in the United States or Black Americans who could trace their lineage to an enslaved ancestor in the United States. And then more broadly, in her words, African American regarded Black Americans who could trace their ancestry to free people of color in the United States. Or in other words, Black people who lived in the United States during the era of enslavement, but may have been, emancipated or manumitted at an earlier date than the larger majority of Black Americans whose ancestors who were emancipated in 1865 by virtue of the Emancipation Proclamation. And so I guess my question to the two panelists, although I know we're mainly talking about a historical overview of the reparations movement, but to your points about that you raised with eligibility, what are your thoughts on Secretary Weber's kind of clear statement as to who she felt should be eligible under the AB 3121 bill text?
When you were having issues with your network, your internet, we talked about that. I guess to summarize it, really, first of all, there were Africans who were never enslaved. They weren't emancipated by anybody. They were never enslaved. They were free, so-called free. I put all of that free in quotes because they were limited and restricted by the laws and the way in which, as we said, the bases of slavery, and one of the bases is white supremacy and the looking at Blacks as inferior, though they were treated in a less than equal way, as even though they were not, in quotes, the property of any white person. Secondly, I think to try and summarize my comments, I think that it does, and I put it in my written testimony too, that you'll get in a couple of days, but I think it does a disservice, actually, to limit the recipients to somehow being able to trace their lineage to enslaved Africans. Because if we look at the call for reparations that Nkechi so eloquently presented historically, if we look at the UN documents that have addressed this issue, you can look at the fact that many people are getting reparations because of the descendancy, and I gave you some examples like the Mau Mau or whatever. But you also look at the legacy of slavery as impacting or being borne by people who are Black Americans, African Americans, people who look like me. And the people, and I keep saying that not because I want, you say, look at me. I'm talking about people who look like, who are dark skinned, who are brown. We also know the history of passing. We know that really what Du Bois talked about was the issue of the color line. And so slavery was part of the color line in many ways. Everybody didn't fit under it, but there was. And so the color line also continues in the vestiges to me. And I think, I know I can speak for my people that I've worked with over the years and in COBRA and other groups, but I'll say to me that we do a disservice. We do a disservice if we only look at what reparations we can give for the legacy of slavery to people who can trace their legacy back to slavery. Because then you won't be able to remedy education. Then you won't be able to remedy any of the structural racism that is, in fact, the legacy of slavery. So that would be my response. I don't know if Nkechi has something she can add.
No, I just would like to invite Secretary Weber to listen to our testimonies. Again, I feel that there should be a rebuttable assumption of inclusion, and that's the basis of much longer discussion that we all should come to the table together and discuss the ins and outs of. So thank you.
Thank you so much, Ms. Taifa and Ms. Ayatoro, for your excellent and informative expert testimony. We really appreciate your presence and honoring reparations advocates of the past, present, and future. Truly, truly appreciate it. So now
Thank you.
Thank you so much. So now we'll turn to witness panel number 2, which is a historical review of legal implications of reparations. So I am delighted and honored to introduce to you all Dean Erwin Chemerinsky. Dean Erwin Chemerinsky is an American legal scholar known for his studies of United States constitutional law and federal civil procedure. He served as the founding dean of the University of California Irvine School of Law from 2008 to 2017 and is currently the dean of the University of California Berkeley School of Law. A study of legal publications between 2016 and 2020 found Chemerinsky to be the most frequently cited American legal scholar. Chemerinsky was named a Fellow of the American Academy of the Arts and Sciences in 2016. The National Jurist magazine named him the most influential person in legal education in the United States in 2017. And in 2021, Chemerinsky was named president-elect of the Association of American Law Schools. Very, very happy to have Dean Chemerinsky here with us. And without further ado, Dean Chemerinsky, you may start your expert testimony when you're ready. Thanks again.
Thank you. Thank you for that kind introduction. My honor to be able to testify before you. I'm here to address one question. How to structure reparations in the way most likely to be upheld by the courts. My conclusion is that reparation is most likely to be upheld by the courts if it's structured in a race-neutral fashion. That is, it's most likely to be upheld by the courts if reparations are for those who were descendants of slaves rather than for all who are Black. In the United States, under current constitutional law, and in California under Proposition 209, laws that give a preference on the basis of race are either inherently suspect or perhaps per se illegal. And therefore the question is, how can reparations be structured in a way that would get through judicial review? Let me talk about two sources of law, the California Constitution and then the United States Constitution, to explain why I've come to this conclusion, then briefly respond to some of the questions that you might have about the position I'm taking, and then answer anything that you want to ask of me. The first source of law that you need to focus on is the California Constitution, what was commonly referred to as Proposition 209. It was called the California Civil Rights Initiative. It says that the state of California and all of its political subdivisions cannot discriminate or give preference on the basis of race in education, employment, or contracting. And so if reparations are given on the basis of race, that anyone who meets the definition of being Black is entitled to reparations because all have suffered from the legacy of slavery, I don't think it could survive a challenge under Proposition 209. Now, Proposition 209 is limited to education, contracting, and employment. And if the reparations were not in those areas, then Proposition 209 wouldn't be a problem. But if it's in education, or if it is in contracting, or if it is employment, then anything that is deemed as a preference on the basis of race is per se impermissible. This is different than what I'll talk about in a moment, the United States Constitution, where there is the possibility of racial preferences being constitutional. Under the California Constitution, they're not. There's relatively little case law about Proposition 209, but that which exists broadly defines what is preference. It would be hard to imagine that there'd be a reparation system that was racially defined that wouldn't run afoul of this. Now, as I said in my introduction, if this were defined as a benefit for those who are descendants of slaves, it would certainly largely overlap with race, but it would not entirely overlap with race. There are Blacks who are not descendants of slaves. There's a very small population that were enslaved that wouldn't be Blacks. So I think there'd be a strong argument based on Proposition 209 that limiting reparations to those who descendants of slaves would not run afoul of Prop 209, whereas if this is defined in a race-based manner, then I think Proposition 209 would be a substantial problem. But assume that Proposition 209 wasn't a problem. Imagine this wasn't reparation about education, contracting, and employment, in which case it would be entirely outside the scope of Proposition 209. There is still the United States Constitution. And the Supreme Court has said now, for over 30 years, that racial classifications benefiting minorities, just like racial classifications that disadvantage minorities, are highly suspect. The Supreme Court has said that racial classifications benefiting minorities, like those disadvantaging minorities, must meet strict scrutiny. As I'm sure the Commission knows, strict scrutiny means that the government action has to be necessary to achieve a compelling government purpose. And the Supreme Court has been very restrictive as to what counts as a compelling purpose in this context. Quite relevant to your Commission, the Supreme Court has said that remedying the history of past discrimination is not a compelling purpose sufficient to justify remedial action. There was a Supreme Court case, Wygant versus Jackson Board of Education. The Jackson, Michigan school system had recently hired a number of black teachers when it needed to have layoffs. It decided to fire white teachers with more seniority. Their argument was that this was to remedy a long history of race discrimination. They also said how important it was to provide role models for black children in the schools. The Supreme Court declared this unconstitutional, and the court's opinion was explicit that there cannot be preferences based on race on the grounds of remedying the history of discrimination. Or there's the case J. Croson versus City of Richmond. Richmond, Virginia, the capital of the old Confederacy, set aside 30% of its public works monies for minority-owned businesses. They did so because even though at that time Richmond was a city that was more than 50% black, racial minorities and blacks were receiving only about 1% of the public works contracts. But the Supreme Court declared this unconstitutional, and the court said the long history of race discrimination, including in Richmond, Virginia, didn't justify the preference that was given on the basis of race. There is now only one area where the United States Supreme Court has allowed race-conscious remedies, and that's in the area of higher education. In a series of cases, the Supreme Court has said that college universities have a compelling interest in a diverse student body, that college universities may use race as one factor among many in admissions decisions to enhance diversity to benefit minorities. This was initially articulated by Justice Lewis Powell in an opinion in Regents University of California versus Bakke in 1978. It was reaffirmed by the Supreme Court in 2003 in Grutter versus Bollinger, and then reaffirmed most frequently and recently in 2016 in Fisher versus Rich Texas at Austin. But in the Fisher litigation, the Supreme Court made clear that college universities could use race as a factor in admissions decisions only if they could prove there was no other way to achieve diversity. Now, it's worth noting that the states can do what would be thought of as protecting more rights than the U.S. Constitution. And so California can prohibit affirmative action even though it would be permissible under the U.S. Constitution. That's exactly what Proposition 209 does. But even as to this one area where racial classifications benefit minority have been allowed, the law, I think, is about to change. The Supreme Court has granted review in two cases for next October, one involving Harvard University and one involving the University of North Carolina. And the issue in those two cases is whether the Supreme Court is going to overrule the earlier decisions allowing affirmative action. Why two cases? Well, the Constitution applies only to the government. Private activities don't have to comply with the Constitution. Harvard is a private university. But Title VI of the 1964 Civil Rights Act applies to entities that receive federal funds, including private entities. Harvard obviously receives federal funds. So the issue in the Harvard case is whether or not race-conscious affirmative action in admissions violates Title VI. in the University of North Carolina case is whether it violates equal protection. It is impossible to count 5 votes on the current Supreme Court that would uphold the Harvard and the North Carolina affirmative action programs. Chief Justice John Roberts, been outspoken in his opposition to all forms of affirmative action. And parents involved in community schools for Seattle Schools No. 1, 2007, he explicitly took the position that the Constitution requires that the government be colorblind. Justice Thomas and Alito have taken the position, and with 3 additional conservative justices, Gorsuch, Kavanaugh, and Barrett, hard to imagine the Supreme Court doing anything but reversing those earlier decisions. Well, what does that mean in the context of the discussion of reparations? If reparations are framed in a race-based manner, then they would have to meet strict scrutiny, necessary to achieve a compelling purpose. And remember, the Supreme Court has said remedying a history of discrimination is not regarded by the court as a compelling government purpose. And so I think it would be very hard to convince this Supreme Court or lower courts following Supreme Court precedent that a race-based reparation program would be constitutional. I think the best hope with regard to the Supreme Court is a program that is facially race neutral, that being framed in terms of a benefit for descendants of slaves would be much more likely to be upheld. There are precedents for reparations, as this commission well knows. For example, there was the reparations provided to those who had been in Japanese internment camps. But it's important to note that that was based on people who had suffered a particular injury, and they were each given $20,000 in an apology during the Reagan administration. It wasn't anyone who was of a particular race. I think it would be hard to convince this court that a race-based program met strict scrutiny was constitutional. On the other hand, what's more encouraging to me that I cannot think of any instance where the Supreme Court has struck down a race-neutral law on the ground that it has a benefit or even a targeted benefit for minorities. As an example, some states have adopted admissions programs where they take top 10% of classes across the state. And this was undoubtedly adopted to benefit minorities, and it had the effect of benefiting minorities. And yet the Supreme Court, at least called dicta, has indicated that would be constitutional, even though the purpose, the effect would be to benefit minorities. So I come to you as the messenger. I am not defending the law as set out by the Supreme Court. It is certainly not the law as I would want it to be. And I completely understand the benefits with regard to praising reparations and framing it in terms of those who are Black. I am simply addressing the question, what is most likely to be held by the courts? Let me just respond to 3 things that might be in mind, and then I'll take your questions. One thing that might be in mind is there is a tremendous difficulty in proving that someone is a descendant of slaves. This will be very under-inclusive in that way. As this commission knows so well, records are incomplete. And so the cost of what I'm suggesting is that many who are deserving would not get benefits. And I think if you go in the direction of providing that those who are descendants of slaves would get reparations, how to deal with the incomplete records and the lack of documentation becomes very important. A second concern is articulated by the prior speaker, all Blacks in this country have suffered from the legacy of slavery. All should therefore be able to benefit from reparations. I think that is a compelling argument, but I don't think the United States Supreme Court would find that to be a compelling argument. If you look at the case I mentioned, where the court says remedying the past history of discrimination is not a compelling interest, I don't see a way of persuading the current Supreme Court, that matter the lower courts, of that. And a final criticism of what I'm suggesting is that there's still the purpose of benefiting Blacks. The effect is still to benefit Blacks. Might a court not strike it down on that basis? And yes, I think that's a risk, even of a reparations law that's framed in terms of benefiting descendants of slaves, but I think it is far more likely to be upheld than a law that is framed just in terms of race. So again, wanted to address just one question for you: how to frame reparations in the way most likely to be upheld by the courts. And I'm glad to take any questions.
Dean Chemerinsky, for your informative expert testimony. I would like to now recognize our task force members in the event that they have any questions, comments for Dean Chemerinsky. Member Reggie Jones-Sawyer, you are recognized.
And thank you. And I missed some of it because I had to step away from a second. But Mr. Chemerinsky, as you probably heard from several other people about descendants of slaves, you probably could hear the pain, and probably the pain of our ancestors who were enslaved, and the harm that was done to them. When you hear their ancestors speak of it, you probably could hear the pain. And I'm thinking of, in the context of lawsuits, there's always this discussion of harm, and normally there's like 3 different things that people ask for. And again, I'm practicing law without a license. People are looking for monetary remedies, some kind of apology or acknowledgement of the harm, and then eliminating the harm. And I say that in the context of maybe we're not providing any benefits, but maybe we should remove the harm. If there's a contaminated lake because of some industry, not only do they try to get them to remove the harm, stop contaminating it and killing people or giving them cancer, but we also want them to acknowledge that they've done that, and that's why they want NDAs done so they don't get sued in a lawsuit. A lot of companies, and a lot of this discussion seems to be about monetary more than eliminating the barriers that slavery has instituted institutionally. Is that may be a way, maybe not providing preferential treatment, but doing things to eliminate the barriers that keep African Americans down, that are based on things that were done in institutionally. It just drives me crazy, because when you read the Willie Lynch letters, for example, we're arguing about whether or not descendants of slaves or Black people in general get money, and that's like straight out of the Willie Lynch book, that the secret to controlling enslaved Africans is by setting them apart from one another. In my mind, that's a vestige of the harm of slavery on Black people, and it's still ingrained in us. So how do we go to stop redlining? How do we go so that, when you try to get an appraisal, usually it's worse in Black neighborhoods than it is in other neighborhoods? How do we stop barriers from people promoting or getting a job, or the whole system of the criminal justice system, and how that's the new plantation system for African Americans right now? How do we remove those barriers? Is that something we could put in? I know that's a lot, but hopefully you get where I'm going. Is there another way we could do this that could survive scrutiny?
Sure. It's a wonderful. Let me take the 3 things that you say, because I think it's a good way of organizing it. In terms of the middle apology, I don't think there is any problem with having the legislature, be it Congress or the state legislature or a city council, apologize for slavery. And so, because it's not giving a benefit to somebody, I don't think that there'd be any problem with that. Of course, it doesn't provide what we most need in terms of eliminating the barriers or monetary, but we should acknowledge that's not the problem. In terms of monetary, and admittedly, implicitly, a lot of what I was talking about was thinking of reparations as was done for Japanese Americans who were interned as a monetary reparation. Then I think defining it in a race-neutral way is the most likely to get it upheld. In terms of eliminating barriers, I think we do need to strengthen civil rights laws. We must strengthen the voting rights law. The Supreme Court has gutted the Voting Rights Act in its decisions in Shelby County versus Holder in 2013, or Brnovich versus Democratic National Committee in its decision on July 1st of 2021. We must strengthen the open housing laws for the reasons you say. We must strengthen the employment discrimination laws. And it's important to remember we can do that here in California for this state, as well as work for it nationally, but we don't have to wait for Congress to do it to adopt better laws in California. But in drafting those laws, it has to be laws that protect against race discrimination, not just protect blacks against race discrimination, because then I think you'd be getting into a preference for a particular race. But I don't foresee, if we could eliminate those barriers, that being a problem. Let me take voting rights as an example. We need to restore what the Supreme Court invalidated in saying jurisdictions with a history of race discrimination need to get pre-clearance, pre-approval. We need to restore the ability to prove race discrimination by showing a discriminatory impact against minority voters. That's constitutional, and that wouldn't run afoul of anything that a court would strike down. Now, what I'm looking for here always is what are proxies that can be used that achieve the same goal but aren't explicit. Let me take what I know best, admission for higher education. After Proposition 209 was adopted, there was a devastating effect on enrollment of blacks and Latinos at schools like Berkeley and UCLA. It took a long time to try to find proxies that we are in compliance with 209. We are not violating the United States Constitution, but we've been able to dramatically increase the students of color. Well, that's what we need to look for with regard to reparations. That's what we need to look for in terms of eliminating barriers and monetary relief. A way that we can find proxies that achieve the goal of getting the benefits to people who need them. Proxies that prohibit and strengthen anti-discrimination law, but that won't be struck down by the courts.
Thank you.
Madam Chair,
Yes, Vice Chair Brown, you're recognized.
well, my brother and members of the task force, with all you said this afternoon to us, it appears that it's our lot to stay at the bottom of the well in this nation. Anything that addresses the historical wrong that's been done to black folks and still continues to be done should not be done, because then you're being, again, quote unquote, race specific. Well, the devil, let's look at San Francisco. You have a population that is diminished from 15 down to 3.9 to 4% of the population. There's been redlining, economic deprivation. Still, after nearly 50 years, there's not equality of opportunity in terms of hiring for black teachers. There's not equality of opportunity in terms of wraparound services for black children. And the facts reveal that right now, those who are in the eastern portion of this city, Bayview Hunters Point, are the worst performing students in this city. And even when you look economically, the per capita median income for black people in this town is $35,000 a year. But for whites, it's $110,000. For Asians, it's between 70 and Latinos between 70 and 80,000. Now, with all that you said to us about the law, it looks like to me that the person who's been cut with a switchblade knife, or who's been gasoline's been poured on, burning them up, we are saying there's nothing that we should be doing to correct that situation. I'm sorry, but that's all that I have heard as we skirted and danced around this issue. That is, Langston Hughes says in his little ditty of 8 years ago, I swear to the Lord, I still can't see why democracy means everybody but me. Everybody else has gotten their little reparations. They got some kind of help. Call it whatever you want to. But when it comes to us, we get bogged down on, I know we got to be smart, but we get bogged down with a cloud of negativity saying the doctor cannot heal the patient. The patient just got to die. And that is what is happening to black folks now in this nation and in this city of so-called progressive liberal San Francisco. And I think this task force needs to work up to it, or else we're going to be a dog and pony show, going through the motions. But like Jack and the Bear, making tracks and get nowhere. And we got to define this thing, quantify it, and stand our ground, hold our hope. And if they don't support us, fine. Be on them. But I don't think we need to be so cautious and hemming and hawing about coming to the point with deliberate speed, as the Supreme Court decision said, May 17, 1954, to do something, or else we're going to be talking about this issue and I'll be dead and gone. And all of us on this panel.
Thank you, Vice Chair Brown, for those statements. And I'll take the space to remind folks that, yes, tomorrow, right after the public comment period from 10:05 to 11 o'clock, we will be discussing the community of eligibility and potentially taking a final vote on who should be eligible for reparations in the state of California under AB 3121. So for folks who are interested in following that discussion, which is a continuation of the discussion we're having today, make sure you log in tomorrow morning for that. Any other comments or questions from from task force members?
Might I
Yes,
just
go
respond
ahead,
to
Dean.
prior comment? I want to be clear. I completely agree with everything that was said about the inequalities that exist and the need for action. I'm here, though, as a constitutional law professor, simply to give you my opinion that if you decide to phrase this in a race-based manner, it is less likely, much less likely to be held in court. And the hope that I would have is there are ways of providing reparations, go to the prior comment, whether they're monetary or limiting burdens, that can be upheld in the courts. Now, you as a commission may say, it shouldn't matter to you what's likely to go on in the courts. All that should matter is what you think is best. In that case, my testimony is irrelevant, and I readily admit it, because I was focusing then on a question that you may choose not to face and focus on. But I can tell you what the constitutional law is on it, and then you can decide whether it should matter.
Quick follow-up question to that, Dean, and it's for the edification of the public, right? But to your point, the United States Supreme Court has decided to take up, these two cases, one in a private institution and one in a public institution. But it's very likely that race-conscious programs might be deemed unconstitutional in the near future. I believe the Supreme Court stated that they will probably come to a decision on these two cases by July 2023, which is the same month and the same year that the Reparations Task Force in California sunsets. And I think interestingly enough, right, racial quotas are unconstitutional in the United States, right? They're constitutional in Brazil, but we're not talking about Brazil, right? We know that racial quotas are unconstitutional here. And so just the idea of a race-conscious program where race, is a factor is under threat in this country. So I guess my question, and you already, laid it out clear, but it's just for the edification of the public, because I think people are still like wrapping their minds around, well, in their opinion or in their viewpoint, right, the history of this country, the harms that Black Americans have faced in some people's eyes have been race-based versus lineage-based, right? They believe that, our harms as Black Americans have been race-based. So why cannot the solution be race-based as well? I mean, you already kind of touched on it, but if you could just kind of reiterate.
Let me say several things. First, the Supreme Court has struck down race-based remedies in every area other than education. And so I quickly went through cases that involved employment, contracting, grants. And one after another over the last 30 years, the Supreme Court has said the government can't use race as a factor in hiring, awarding contracts, and the like. The one area where the Supreme Court has upheld affirmative action, race-based programs, has been with regard to higher education. And it's that which the Supreme Court is taking up next October. In terms of timing, the case will be heard the first week of October. It'll come down sometime in the spring of 2023. No way to know whether it'll be April or May or June of 2023. They'll come down then. And I don't think there's anyone who studies constitutional law who would tell you it's likely that the Supreme Court is going to continue to allow affirmative action. You are, of course, absolutely right that the harms that Blacks have suffered are race-based. And I think if what we were talking about is proving that particular individuals had suffered civic harms from the government, there would be no problem with the discussion. This is what the government did when it provided reparations for those who were interned. Those who were still alive each got $20,000 from the government. But when you talk about providing a benefit for race because of the general history of discrimination and the legacy of discrimination, that runs exactly against the Supreme Court's decisions, where the Supreme Court has said that the history of discrimination just doesn't justify race-based remedies today. So I want to be clear, as I said to you, I'm not defending what the Supreme Court has done. If it were up to me, I would do it completely differently. I'm just here to tell you what the Supreme Court has said so far and what they're likely to say next year.
Thank you, Dean. Member Tamaki and then Member Holder. Hear you, Member Tamaki. No, we can't hear you. Now you're on mute, so maybe try to unmute again. Oh, we'll go to Member Holder, and then we'll go to Member Tamaki. Member Holder, you're recognized.
Thank you. Thank you, Professor Chemerinsky. I'm a big fan of your work. Had the opportunity to work on an amicus brief with you when I was legal director at the Equal Justice Society, and really enjoyed that. I too am an attorney and a constitutional scholar, and have done a lot of work around Proposition 209, including being one of the people on the steering committee for Proposition 16, which was the initiative to eliminate Prop 209, which unfortunately didn't pass. So a lot of my scholarship has been around Proposition 209 and the restraints. I wanted to underscore one thing that you said, which is so critical in terms of educating the public, is that Prop 209 puts restraints on government employment, government contracts, and government education, right? Now, those are obviously critical areas, but in this task force, we have heard testimony about the history of racism and the continuing harms of racism in other areas, such as housing, right? Tremendous harms in healthcare, where we have a Black women's health crisis, where, as a Black woman, birthing mother, you're 3 times more likely to die from childbirth-related illnesses. Black newborn babies are 3 times more likely to die during in delivery if they are delivered by white doctors. So that's, and there's the statistics are overwhelming in terms of life expectancy, mental health issues, et cetera. So in healthcare, that's one discrete area. And in criminal justice, we all know the statistics about inequality, continuing inequality, which is clearly a legacy of slavery that disproportionately impacts African Americans. So I've just outlined 3 areas: housing, healthcare, and criminal justice that don't implicate the areas that Prop 209 regulates, right? So the first part of my question is, if we focus our regulation on those areas that are not regulated by Prop 209, what would be how successful could we be in transcending the Prop 209 hurdle, and in terms of the federal hurdles with equal protection? And then the other thing I wanted to ask you about is, I completely agree that the court has said time and time again that we do not allow remedies for past discrimination based on race. However, there are cases where the court has said current manifestation of discrimination, and especially when that discrimination is advanced by the government. Current discrimination in government contracting, for instance, can be remedied if you can show through a disparity study the impacts of that ongoing discrimination. What we're putting together is a 1,000-page report, which is a massive disparity study that could essentially fit that framework of showing the ongoing disparities that would allow you to legislate and regulate around race. I just wanted to get your comments on both of those.
Let me address each of those points. As to the former, you're absolutely right. If reparations were framed in terms of housing, healthcare, criminal justice, Proposition 209 wouldn't be applicable. As you rightly point out, Proposition 209 only applies if the government gives preference or discriminates in education, contracting, employment on account of race or sex. So if you stayed away from those 3 areas, you wouldn't have any problem in terms of Prop 209. There could still be a challenge under the Equal Protection Clause of the U.S. Constitution, but an advantage there is if you have a compelling interest, then it would be constitutional, whereas even a compelling interest isn't enough under Proposition 209. As to the second question, you're also, of course, correct that if it can be proven that there is current discrimination, there can be a remedy for those who have suffered that discrimination. The classic example would be if you can show that an employer is discriminated on the basis of race, a remedy can be imposed as against that employer. Where I pause is, if this were structured in terms of a benefit that all who are Black would be able to receive, I'm skeptical that a court would allow that kind of race-based remedy, even with the tremendous proof of discrimination in your report. That's why I say if you can find proxies for race, it's much more likely to be upheld. I think there's a difference in the eyes of the court between saying, you've proven that this entity has discriminated against this group, therefore give a remedy to this group, and saying everybody who's of that race should get the benefit. And I understand that logically you could say everybody who's Black has suffered from the legacy of discrimination, therefore everyone who's Black should be able to get the remedy. I'm skeptical that the current Supreme Court or lower federal courts would accept it. But you may decide that's how to go forward, and if it's struck down, it's struck down. I'm just here to give you my opinion of what is the way to structure this that's most likely to be upheld.
Okay, and if you can indulge me with one more question, I'm so grateful to have you here. So just indulge me for a second. I'm also interested in the 13th Amendment and deploying the 13th Amendment, especially the second clause of the 13th Amendment, which says that Congress should regulate and pass laws that prohibit the vestiges of slavery.
Yes.
And that to me is the way to that is the action that sort of actualizes the compelling interest. Legislators need to regulate to prevent things like racial profiling, anti-Blackness, because those are the vestiges of slavery. And we have authority for that under the 13th Amendment. So what about taking that?
Oh, I think it is a terrific idea. Section 2 of the 13th Amendment allows Congress to adopt laws to enforce the 13th Amendment. The Supreme Court, in cases since Jones v. Alfred Mayer in 1968, said that gives Congress broad power to eradicate the badges and incidents of slavery. And so I think that if it were a federal effort at reparations, I would focus it under Section 2 of the 13th Amendment. Again, I think that if this were lineage-based, or if this were race-based more generally, I think it is the greatest chance of success. I think if it is saying that all who are Black have suffered from the history of discrimination, that all who are Black will get a benefit or be protected from discrimination, but other races don't get, I think that'd be much harder to sell to the court, even using Section 2 of the 13th Amendment. But I agree with you, that's the best basis for doing it.
Thank you.
Tamaki?
Do
I
you
can't hear you for a second.
want to put your question in the chat?
I was going to suggest that. Time check, 12:41.
If
We have
Commissioner
about.
Tamaki wants to send me an email with the question, I will respond to him in the commission.
Okay.
So if you just
Any
send me
other
my
last?
email address, just if you've got my email address, send it to me. The only thing I'd say in conclusion is I so applaud the work of the commission, and I'm available to help you in any way I can.
So much, Dean. If there aren't any other last comments or questions from the task force, I would like to thank you so much for your presence. I know it's been a hard kind of, tracking you down and getting you scheduled. So this is very serendipitous. Thank you for joining us on this celebration of Black History Month and reparations advocacy.
Thank you for having me. It's my honor. And again, anything I can do to be of assistance to you would be my pleasure. Thank you.
Thank you so much. Member Tamaki, if we can hear you.
Can you hear me now?
Yes, we hear you. Okay.
Oh,
Sorry,
I'm so sorry. I don't know what happened to the microphone. And Dean Chemerinsky, if you could indulge me along with the other members. Well, and thank you, Camila, for calling on me. So my question is, if it's a harm-based remedy, not a race-based remedy, but a harm-based remedy, where is the line of demarcation on the harm? For example, if we're talking about enslavement and emancipation follows in 1865, I hear that you're saying that's the harm that can be remedied. But the next era is Jim Crow, well-documented period of oppression. Period after that, you might call separate but equal, and so on and so forth. And if someone, for example, has a difficult time proving lineage going back numbers of generations, and they can only go back so far, and hypothetically, let's say it's post-emancipation, it's not during the period of enslavement. I realize these are issues, but I'm saying if we go with a harm-based remedy, how far can you go back? What is the basis? What might be recognized as remediable harm? Does that make sense? Is Dean Chemerinsky on? I don't see him.
I think he may have left.
Oh, okay. Again, I had technical issues, but maybe we can revisit that in another discussion.
Yeah, and he did say that he'd like for you to send him your question.
Okay.
Yes, sorry about that. Oh, I didn't know. Okay, well, thank you to our esteemed panelists, Ms. Taifa, Ms. Ayatoro, and Dean Chemerinsky, and also thank you to our esteemed Reparations Task Force members for this excellent discussion that we've had before the lunch hour. So now we'll break, and then we'll come back at 1:30 p.m. for our third panel of the day, which is recognizing current efforts at reparations. And we'll hear from Professor Mary Frances Berry, who wrote the book My Face is Black is True, Owen Callie House, one of the earliest reparations advocates in the United States. We'll also hear from Ms. Deidria Farmer-Pellman and Chad Brown. So without further ado, thank you all so much for holding it down since 9 a.m. And we will break now and return at 1:30. Thank you.